Okay, good afternoon, everyone. Welcome. Before we start our official program for the Northern District's Historical Society, because in so many ways we are a court family and many of our court family members are here, I did want to give our U.S. Attorney, Craig Misakian, an opportunity to say just a few words about a beloved member of our court family.
Thank you, Judge. I imagine that the sad news of Andy Scoble's passing has been heard by everybody in the district, in the courthouse. It is a very sad day in our office. He leaves a huge hole behind. He is one of the giants in the office. He was a mentor, a role model, a tireless worker in the interests of justice. Somebody who set the bar just so much higher for the rest of us, and we will miss him deeply. And he's one of those people that you meet him, you get to know him. He's one of those people that just makes everybody that he touches just a little bit better. And we were so grateful. I'm personally so grateful to have crossed paths with him for what seemed like a very short time. I spoke to him by phone just last week, just wanted to check in on him. And he was his usual upbeat, happy, positive self. And he asked me if we could send him some of his favorite pens. He had, I understand, a very specific pen that he liked to use to do his work. And he literally worked to the very end. And I think it kept him going. I think doing the work, interacting with his friends and colleagues, it gave him strength and energy, and it allowed him to fight. And fight he did. I know there was a time when he had an opportunity to retire, and he told me that he had a very brief conversation with somebody in the office. And the person said, "Well, look, are you happy doing what you're doing?" And he said, "Yeah, I can't think of anything I'd rather be doing. So why retire?" And he didn't, and he kept going. And he was a presence in the office and in the department. And I knew beloved figure in the among the bench and the bar. And it is my hope that when we have a celebration for Andy, which will be at the end of this month, most likely March 27th, which is Thursday, that you will consider being there to help celebrate an incredible man and an incredible life. Thank you, Judge.
Thank you so much. Welcome, everyone. My name is Kathleen Winters, and I'm the Executive Director for the Northern District Historical Society. A warm welcome to all of you joining us this evening in person and via Zoom. I want to give special thanks to our co-sponsors for tonight's program, the law firm Cleary Gottlieb and the Ninth Judicial Circuit Historical Society. We would also like to acknowledge Nancy Nishimura and Joe Cachette for their generous donation of the wine for the post-program reception. Our co-sponsors and our individual and law firm members make this event and others like it possible. We're also grateful to the 450 Golden Gate building operations staff for their help this evening. And as with all of our programs, Alex Murray of the NDHS took care of countless details behind the scenes. Thank you, Alex. A few reminders: if you registered for CLE credit and are here in person, please be sure to sign the CLE attendance sheet and complete an evaluation form before you leave this evening. For virtual attendees, we will monitor your attendance online. And then finally, if you've not already done so, please silence your cell phones. It is now my honor to hand the microphone over to incoming Chief Judge Yvonne Gonzalez-Rogers, who will introduce our stellar panel. Judge Gonzalez-Rogers has served on the Northern District Bench since 2011, when she was appointed by President Barack Obama. She is the Ninth Circuit Representative to the U.S. Conference Committee on Defender Services and has chaired the Northern District CJA Committee for well over a decade. We are grateful to have her here tonight as our moderator.
Thank you. Okay, as chief, I'll figure out how to do that. When I sit on the bench, it's just automatically on, right? All those people who help us out. It's really my great privilege to be moderating this panel, Criminal Justice Act in the Northern District of California, the origin story, the early cases, and its lasting legacy. When I pulled together this panel with the help of our organizing committee and I started talking to the panelists, I just loved the stories and learned so much about the early days. And I hope you enjoy these as I have. My biggest challenge will be trying to rein them in so that we don't go on forever with just one person. And you'll excuse me if I interrupt them periodically. We're going to start today with Bill Osterhout. Before CJA, before 1965, to set the stage. So that you know, Bill graduated from the University of Washington and Hastings College of Law, now UC Law San Francisco. He was an associate editor of the Hastings Law Journal and graduated in 1968. And before going to law school, he served as a U.S. naval officer on destroyers assigned in the Pacific Fleet in Japan, California, and Vietnam. He's practiced for over 50 years and is an expert in criminal law appellate work and post-conviction matters. A fun fact, and I have one for each of the folks that I learned today, was that we have to be careful with his temper because I'm told that he's thrown typewriters out of office buildings, that he cracks pencils, that he throws fits. And I've had him in court. He's the most gentle person I've seen, but he claims that it's not true. But anyhow, we're delighted that he can be here with us and give us a sense of the before days. So Bill, what was it like to be a defender before the implementation of the CJA, before the Federal Defender Office, before the CJA panel members even existed? And how did you become involved?
Well, it was not well thought out at all. But I was in Hastings. I got out of the Navy. I had no idea what I wanted to do. I wanted to go to law school, but I had no idea. I had no ambition, to be a criminal lawyer. But it occurred to me after about maybe the first year, I guess, that people were getting jobs for the summer. I hadn't thought about that. And so I thought, well, I'll check and see what there is. Well, there wasn't much. And most of the people gone to these firms and stuff had already taken these jobs. And I saw a sticker, though, on a board at Hastings, the Legal Aid Society of San Francisco. And it mentioned an office on Market Street and a guy named Tom Rothwell, who was the head of the Legal Aid Society. So I went over there and I saw Mr. Rothwell, and he said, well, I'm glad you came over. There's nothing for you here, really. But over in the federal building, the judges have set aside a little office on the 17th floor to represent people who can't afford a lawyer. And Jim Hewitt, is the lawyer in charge of it over there. He's a kind of a roly-poly guy. He's affable and well-liked, a good lawyer. Go talk to him. So that's what I did. So I went over here. I went to the federal building, and I went to the 17th floor, this little office at Legal Aid Society of San Francisco, Federal Criminal Defense Office. So I went in and I met Jim Hewitt, and that was a remarkable guy, very interesting, thoroughly excited about the idea of indigent defense, because there wasn't any federal public defender, but he he envisaged that there would be one, and of course he hoped he would be it, but I mean, he really wanted that to happen. And so he developed contacts all over the country with people who have a like mind. I think he testified in Congress and he knew people that did. And he really never got off the pedal of really pushing hard the idea we should have a defender system. And so in the meantime, there was a legal aid society. And so there was just Jim, and there was Danny Weinstein, who many of you know, became a highly respected judge and founded JAMS ultimately. A great guy from Chicago. His dad was a well-known rabbi there who was part of the Interfaith Council of Rabbis that Roosevelt had appointed during the war, Second World War. So he was well respected, and Danny knew a lot of people in Chicago, and he was a good guy. But he was learning, like everybody now, he was learning how to practice. And so Jim, there was Danny, a couple of people put in and out. Harry Singer, who my later partner, he got there about the same I did for the same reason. Rothwell sent him there too. And Harry was in a Hastings, but in an afternoon class, whereas I was in the morning. But we met there. And Harry says, we got a good deal. This guy, he's asking my advice already about stuff. You were brand new lawyers. Because Hewitt did that. He knew everybody. And he listened to everybody. So that's where I started working as a work study student. And I got interested, of course, in criminal law because it was still the Warren Court was still in force, although it was fading. The court was changing, but still the revolution in criminal law that had come with Miranda and other cases that had come along during the Warren Court was still very fresh. And so I started writing briefs and stuff for these people. And I was writing briefs, and ultimately I wrote a law journal article about federal evidence, impeaching people with their prior convictions. It was before, of course, people used 403 for those kind of purposes, but it was very interesting. And he knew everybody in town. So not only would we go to court and watch Hewitt and Danny, but also we would see all the good lawyers. He knew everybody, Vince Hallinan and J. Martin McGinnis, and all these people. F. Lee Bailey came to town to represent these two kids that had explosives in their house in the Pacific Heights with his big booming voice, F. Lee Bailey. So we met him, and we met Helen and Vincent, who had just sued the Catholic Church for fraud because they promised people there was a heaven, a hell, and a purgatory, and they had no proof of it. So it was constructive fraud. And we met all these people and sat through the cases and the judges, and came to know the judges of the day. The judges of the day were kind of very crusty, kind of self-confident in their own infallibility. There was no sentencing guidelines or mandatory minimum sentences to constrain their power, and they regarded themselves as all powerful. But they were mostly good people, mostly people that you could kind of talk to and trust, and who appreciated a person like me was new and critiqued our performance to Hewitt when we began to practice. And that came later, because what happened was I stayed there that summer and the next, and I thought I got really interested. And then they hired me. They hired me a job. Of course, we didn't pay any money, but that's one of those things, But there was constant trials then, mostly bank robbery. Our office was doing mostly bank robbery cases. You didn't have a big drug practice yet. It was just developing. The war on drugs just getting started. But there was armed bank robberies and there was unarmed bank robberies. And there was dire acts, thefts of cars, interstate commerce that Hewitt felt just ran up the FBI statistics. And then there was counterfeiting, quite a lot of counterfeiting cases. And there was a few Mann Act once in a while. But mostly it was, these guys, it was once in a while interstate commerce fraud. But federal jurisdiction was really very limited. And we didn't have the big explosion in drug for a while, So that was what it was like. And the office was small. It didn't have any accoutrements of an office. It was a room, kind of a big room, and there were offices we were around. There was a desk in the front of it. Diane Holloman was the name of the secretary. Wonderful woman, a single mother. struggling because, you know, she had a desk and there was no refuge for her. Like what happened was the people would come to her office, would come to the federal building acting a little crazy. And where shall I go? I'm electric and they're going to kill me today, whatever, you know. And they would send them to our office, the Federal Criminal Defense Office. So they would burst through the door and Diane was, you know, would have to seconds to decide whether to push this button would bring the marshals down, which he had available to her. And they would run down, you know, and burst in the door and take care of it. So that was what it was like. And we meanwhile would retreat into our offices, you know, dotted around the front and say, "Oh, good dawn, Diane, survive that." And then Hewitt would take care of it sometimes. In his personality, it's sort of an insight that he would want to take care of it more quickly. He didn't want to call in the marshals, so he would come out and he would try to diffuse when people were doing that. They would say, "I'm going to be executed today," and he would say, "What's your name?" And they would say something, and he would look at a piece of paper and say, "No, not today, no, not today." I'm electric, you know. You know, coil in my brain has electricity, and he would say, "Oh, let me ground you. I have a thing here. I can, you know, just wear this." It sounds like he had no compassion, and it wasn't that. It was just that everybody's busy, and they kept sending damaged people that needed help there. That's the best sometimes we could offer them, but that happened. The judges all respected and liked Hewitt, and he had wonderful relations with them. And that made life a lot easier for a young office like that. We had very little money. I think they paid, the first year it was nine grand a year. The first year, the second was, it went up to 15, you know, and so it wasn't easy, but every day we were trying these, you know, when I finally got hired there, when I graduated in 1968, we were trying these cases all the time. And I said, "Jim, I can't, how can I just a new lawyer, I know nothing. How can I do this?" Oyster House, he called me. "Don't worry, you're better off than, you know, lucky to have you. At least you care." Some of these fart whistles in town can't say that, you know. He always called people fart whistles if he was mad at them. And so that's what happened. So he took these cases and you just try them, you know, and I watched Hewitt and he has his own style. You know, every case was shabby. He would argue to the jury, "This is a shabby case." And the worse it was for the defense, the shabbier it was. And he described it. And the government should be ashamed of bringing this case, ashamed. You know, that kind of thing went on all the time. And we picked up things from it. And a great judge named Burke would say, "You're developing some of the worst tendencies of Mr. Hewitt, you know, one of the worst. I'm very worried about it." But mostly the judges were great. Anyway, that's the kind of atmosphere that we had. And I think we, before yielding and getting out of here, I would just like to say that I think he set a standard, you know. I think we really worked hard and people started respecting the office. And other lawyers would come over and they would tell their clients, "You're well represented there," or your co-defendant should be there. And of course, if you needed conflicts lawyers, Jim would just know these people. There wasn't any panel. So he'd find the person. The person would come, Stepanian, people like that would come and represent people.
Let's bring one of those people into the conversation.
So that's how it was. And when I first started, and there wasn't any public defender. And then I saw it begin. And that was very interesting.
So we have with us retired Judge James Larson, goes by Jim to many of us here. Judge Larson grew up in Claremont and went to Stanford. Graduated from Stanford in 1965 and then went back down to Southern California and graduated from UCLA Law School with moot court honors. He started then practicing in LA, but for our purposes moved back to the Bay Area in 1970. And in the 70s, he opened up a partnership with Doran Weinberg, who has been mentioned, specializing in criminal work at all levels, state and federal. And he was part of the CJ, which he's going to talk to us a little bit about. He, as many of you know, was in 1997 appointed as a magistrate judge and was the chief magistrate judge for 5 years. So a little fun fact about Jim. He was the youngest president ever of the National Lawyers Guild. He is a jazz enthusiast and a jazz expert. And now is taking and learning how to play the piano, which is pretty cool, I think. Anyway, Jim, if you could tell us, right, those early days when you were up here in the 70s, how did you become a CJA member? And what were those early cases like in terms of panel appointments?
Thank you. It's a pleasure to be here and to see all you folks. In a way, it's too bad we just can't reconvene outside with the bar and tell stories all night, but here we are. So, around the time that Bill was talking, we're essentially contemporaries, although he's much older than I am. I moved up here in 1972, and we were both a part of a generation of new young lawyers who were basically not so interested in making money, but in trying to serve the public interest. And there were some pretty heavy-duty political issues going on at that time, as I'm sure you all recall. The civil rights movement was in full bloom. There were national liberation groups all around the world, Cuba, Vietnam, and here in the United States, the Black Panthers became a force in the East Bay. And we had the Vietnam War and the women's movement at the same time. And so some of these cases started working their way into federal court. There was quite a large movement against the war in Vietnam, and many young men were being drafted, and some of them started refusing induction for various reasons. One of them was that they were conscientious objectors and they didn't believe in war at all. And these folks started getting prosecuted, and their cases were filed here in San Francisco. The bench of the Northern District developed a reputation for being fairly lenient with these cases. And even if they had not established that there were conscientious objectors in classic view, and they were guilty of refusing induction, if they could establish their good faith belief that they were conscientious objectors and they were otherwise not ordinary decent criminals, they would get sentenced to probation. And so the Northern District of California gained a reputation all over the country of being lenient on these cases. And the result was that hundreds and hundreds of draft registers started transferring their inductions out here to San Francisco, where they could refuse induction. If they got charged criminally, then they would wind up in this court. And the worst that they could expect, if they could establish some level of sincerity and otherwise goodwill, there would be sentenced to probation. And as these cases proliferated literally into the hundreds, we had to figure out a way to provide representation, because most of them were students or otherwise unemployed, couldn't afford to hire counsel. And of course, this was a specialized area of the law. Not too many people knew anything about the draft system or what it might constitute a defense or how otherwise to deal with these cases. So with the cooperation of the chief of the criminal division in the U.S. Attorney's Office and the Federal Defender's Office and Judge Peckham and some of the other judges who were on this court at this time, decided we should put together a panel of attorneys that were experts in selective service law and could handle these cases. I had been working with a guy in the law firm that I started with in Los Angeles who was an expert in selective service law. And so I had learned the ins and outs of the law and was involved in counseling, and actually had, with another guy, set up a draft counseling center at the law school at UCLA before I graduated. So I and my then partner at that time, who also was well versed in criminal law, joined that panel. Mike Stepanian was on it. Well, Bill, were you on it? I can't remember.
No, I was in the office then, so I was.
But anyway, there were quite a few lawyers that were involved in it. And what would happen is somebody would move into town, they'd get called for induction, they'd go down to the induction center, they would refuse to step across the line if they had passed their physical or otherwise qualified to be drafted. And thereafter, they would be charged with violating the law. Cases would wind up here. We'd go down to the clerk's office and pick up the indictments. And basically, the proceedings here in court were a review of an administrative determination. So the facts of the case in terms of whether or not you were a conscientious objector or not, for example, or had some other problem, findings of fact would be made with regard to that at the administrative level. And so the function of the court in a criminal case was just to review the legality of the process. And if there were no errors, there really was no basis for a trial. So most of these cases were handled on assignment to a defense lawyer, review of the file, determination if there were any legal or constitutional issues that could be raised in defense, and reviewing the procedural history of the case to determine whether all the I's were dotted and all the T's were crossed. And then it got into court, there would be the usual arrangement on the setting, delay for discovery and preparation of the case. And then a date would be set for a motion to dismiss. And at that time, all the arguments that you could make regarding procedural irregularities or otherwise, as well as some kind of introduction to the personality of the defendant and his history, could be brought to the attention of the court. And if the motion was denied, then the court declared a conviction. There was no jury trial or any other court trial, and the matter was referred to probation for report and sentence. And at this point is where the behaviors really came into play, as the history of the court had established pretty much at that time. If you were a sincere, conscientious objector, even though you might not even have applied for that at the draft board level, if you could convince the court that you were sincere about those beliefs and were otherwise a person of good character, you were likely to get sentenced to probation. So that was the goal in almost all the cases. So we handled literally hundreds of those cases during a period of time. During that time, we had a slight sea change in the court, and 3 new judges were appointed, starting with Judge Conte, who, by the way, wound up becoming a very good friend of mine. But he and 2 others took an entirely different view of the draft cases. And so if you were found guilty and you didn't have any other defense, people started getting sentenced to prison, 2, 3, 4 years, sent out of state to a federal prison, usually in Arizona or somewhere else. So things kind of changed and it got a little heavier around here. Part of the energy that was spent by the CJA draft panel was to try to educate the new judges a little bit about what the history of this district had been, and also to try to adapt to what was going on. So things went along and along. There turned out to be more trials. People would try useless defense and lose and go to prison. I had one of the few jury trials during this period. I was representing a working class kid from Richmond who had refused induction. He was not a conscientious objector. He was just a nice working class kid, had never been in any trouble before. And when I asked him, well, what happened? He said, I just couldn't do it. I just couldn't do it. So I thought, well, what am I going to do here? And I talked to a psychiatrist who was sympathetic to the cause. And we underwent some testing. And he reached a diagnosis. And the diagnosis was that when it came to the end of the procedure at the draft center, and he had been found qualified, he passed his physical and everything else, and there was no other reason why he couldn't be inducted. He was unable to step across the line. He just froze. He just froze. And the psychiatrist diagnosed him as having a dissociative reaction. So we went to trial on that defense, had a jury. It was before Judge Harris was one of the older judges on the bench even at that time. And the prosecution's case was fairly cut and dry. By the way, there were just 3 assistant U.S. attorneys who were assigned specifically to draft cases, and they were from all over the country. So they put in a case, which was basically to put in the file and establish the fact that at the time that he was called upon to step forward, he failed to do so. And then we went on to the defense. In the course of preparing the case, of course, when I disclosed that we were having a psychiatric defense, the government became entitled to its psychiatric examination. So their psychiatrist came on at the end of the prosecution's case. So we're in this courtroom, I believe, or one just like it, maybe a little smaller. The door opens, the psychiatrist walks in, and the judge looks down and says, Dr. So-and-so, how are you? I haven't seen you in years. It's so good to see you. The jury's sitting there watching all this, and I'm going, oh my God, I need a recess, or I'm going to have a dissociative reaction. So anyway, we put on our defense. It went fairly well. The cross-examination wasn't much because what was there to say? And the jury went out, and they were very apologetic afterwards, but said, well, you did a really nice job, Mr. Larson, but we had to find your client guilty. So then the question is, what do we do about sentence? Well, we have this tradition in this district of leniency if sincerity can be established. So we put together a presentation to the probation office and the court. And in that case, Judge Harris went back to the old format.
Yeah, he wants you to be closer.
Wants to be closer?
No, you're good right there. Don't think back.
Okay. Sorry, I'm not the techno expert here. So sentence him to probation. And that was one of the most unusual cases during this period. But in any event, the situation changed with the draft, as you may recall. It became a lottery system at a certain point. And the terrain kind of changed a little bit because a very unusual defense emerged during that period. We found this guy who was a law student at Ball Hall then, who had figured out that the rules, the administrative rules governing the draft boards was that people had to be drafted in the precise order in which they became eligible. So what developed was an order of call defense.
It's amazing, amazing defense. They didn't call you on time, you can't tell them to go.
So we get the case assigned and send Steve down to the draft board to go through the file and see what happened. And if he could come up with just one person that should have been drafted before the defendant, you were free. Motion to dismiss, granted, no question about it, end of the case.
And that was the start of the creativeness of defenders in
Right,
the Northern District.
right.
So I'm going to move to Karen in a second. I do have one question, which is, you said there were hundreds of these cases filed. Did that mean we had hundreds of defense lawyers? I mean, we obviously had a small group in the defender's office. How many, just ballpark, how many people were working with you on these cases?
How big was the panel originally, Jim? Do you
I
remember?
can't remember. It was something upwards of 20 to 50, I think, at some point.
Okay.
We helped to form it, I think, because we had the office. We knew we couldn't do all these cases because they were ballooning like this.
Right.
Yeah,
And these guys were inventing these amazing defenses like that. It was
Yeah.
fun to see.
Well, let's talk about women. We haven't talked about women yet. So I want to introduce to the conversation Karen Snell. I'm just realizing, looking at my notes here, we do have the Stanford contingent. So Stanford undergrad, Stanford law. Then she went to Morrison and Foerster before joining the Federal Defender's Office in 1989. And she ultimately became the supervising attorney for training trial attorneys. She now, or thereafter, actually not now, but she served as general counsel for the Institute of International Criminal Investigations. She's been an expert witness on detainees and prisoners' rights. She's a fellow of the American College of Trial Lawyers. She's a founding member of the San Francisco Women Lawyers Alliance. She's taught legal ethics in the Northern District and lectured on trial advocacy. I have a fun fact for Karen, but I'm going to wait because I'm pairing it with Jeff's, and you'll know why when I get there. But Karen,
nervous about this.
Karen, could you bring we have so many women lawyers now. In fact, in the Ninth Circuit, most of the defenders are women today, which is amazing. But can you tell us a little bit about what it was like to be a woman back then? Well, practicing with not just these two, but all the others who are not here.
Yeah, well, I'll back up a little further to the period when Jim Hewitt was the federal defender, and he had the one woman rule that didn't even start till after Judge Patel came on the bench in 1980 and forced him to hire at least one woman. So for his tenure, there was one woman at a time in the office here. Pat Trumbull was in the San Jose office. She ran that office and did a fantastic job. But that didn't influence him to hire more women. So that's where I'll start. And lest it sound like the federal defenders was the only office that had such a problem, the U.S. Attorney's Office also just had one woman during that time period, and that office was 10 times bigger. So we owe a lot to Judge Patel, the women in this district, and I'd just like to say a few words about her. She was appointed, I'm sure you all know most of this, but she was appointed in 1980 by Jimmy Carter. She'd been a civil rights lawyer specializing in women's rights, and she had represented the National Organization for Women. So I like to imagine what it was like when she went into the lunchroom here for the first time and came upon this old boys club, literally. And I'm sure that she changed them in many ways that made the practice in this district for women much better. And so we all owe her a debt of gratitude. We also owe a debt of gratitude to the first women who were in the office, the single women that worked there one after the other. And it's an impressive roster. Claudia Wilkin, Chris Argatis, Karen Sorensen, Sam Meadows, and Victoria Belko. And through their excellent work and hard work and their winning cases, they paved the way for the rest of us to be more accepted when we came into the office. So, well, and one more person I have to mention, the private bar, and in particular, Penny Cooper, who for me was such an important role model. She and Chris were in private practice. They competed with the men for the lucrative cases, and they often won. They worked hard. The judges respected them. They won trials, and they wore pantsuits. So I learned a lot from going to court and watching Penny take apart a snitch and watching Chris present her meticulously prepared cross-examinations. So they were just critical to me developing as an attorney. When I worked at Morrison & Foerster, I worked under Jim Brosnahan, who was a wonderful teacher and a fantastic lawyer. But I knew I could never practice law like him. I didn't have the booming voice. I didn't have the aggressive personality. And to have women to watch and learn from was so important. So when Barry Portman became the federal defender in 1986, he hired more than one woman at a time. And when I came into the office, there were actually 3 other women working there. Deborah DeLampert, Nancy Pemberton, and Nancy Clarence. And that was just a wonderful experience. The men were good too, especially some of them. But Barry was a fantastic boss who encouraged, well, when I was hired, his rule was he wanted us to leave the office within 4 years. He wanted us to get experience, to experiment, and to go out into the world and do good law. And he was a great boss in that he didn't micromanage your cases, but if you needed help, you could ask him and he would provide it. And I have a vivid memory of this one day where he provided that help to one of my colleagues, where her client showed up for trial wearing the sweater that was in the surveillance photo. and I remember Barry around the office looking for a shirt and finally finding one, and the gentleman changed into the shirt before he went into court. So at least that he didn't have that problem. That's not to say that I didn't experience sexism, like I'm sure all of the women in this room have at some point in their practice. One occasion I'll mention is when one of my colleagues walked into court for her first court appearance as a federal public defender. A panel pinched her bottom. And she turned to him and said, "If you do that again, I'll kick you in the balls." And that solved the problem for her. I don't know that it solved it for everyone else. And I had my own experience where I saw 2 U.S. attorneys and they were smirking at me, and I looked at them and they said, "Oh, we're just imagining you doing your argument in the nude." Did it take the wind out of my sails? Yes. Did I report it to anyone? No. I'd had a close friend who'd had a much more egregious thing happen to her in big law, and she was the one who had to leave the firm. It's against that backdrop that there was an infamous disciplinary proceeding in this district involving a great criminal defense lawyer, Michael Metzger, who was referred to a proceeding in front of Judge Armstrong with a civil attorney prosecuting him for comments he'd made to 3 different U.S. attorneys. He had invited 2 male attorneys to a fist fight, and that didn't go over well. And then there was a female AUSA, and after she had denied his client compassionate release and asked for a handwriting sample, he left her a voicemail saying, well, I think you should provide a tissue sample so we can find out what species you are. It was a horrible thing to say. But the public hearing where Bill was one of the defense lawyers was just humiliating. And it was a painful time for all defense lawyers. I mean, especially, we'd all had comments similar to that thrown at us, at least the women had. And then to see someone taken down like that and was really very painful for all of us and for Ms. Teeters as well. And, in retrospect, I have more sympathy for her than I did at the time. I think the Me Too movement helped me as well as a lot of other people realize, just how hard it was to be a woman lawyer back then. But in any event, his discipline was that he was barred from the practice in federal court for 6 months, and he died before that time was up. So it was just horrible. But it was after that this court developed or adopted Civil Local Rule 11-6 that set up a standing committee before which judges could refer misconduct matters and others could as well. And they would be handled in a peer review context and with mediation. And to my knowledge, there hasn't been a public hearing like Metzger's since then. And I think that's a benefit to all of us. But it also reminded everyone in the local rule that everyone is expected to read, that we have a duty of civility to one another, and in particular not to display bias based on sex, race, or any other characteristic. And I think it's made this district a much more civil place to practice. And I didn't realize how much more civil we were until I practiced in other districts where they don't have such a rule, and it's just brutal. So I feel very, very fortunate to have spent my whole career appearing before a bench that was influenced by Judge Patel. And it's just been a great place to be a woman lawyer.
Thanks, Karen. So our last speaker, before we may open it up for a few questions and we may get a few more interesting stories, but Jeff's kind of going to bring us current in a sense. So Jeff Hansen is well known by folks in the audience. He graduated with distinction from Stanford and then attended Boalt Hall, now UC Berkeley, where he earned his JD. And then he worked at the Ninth Circuit as a court law clerk, a division chief of staff, attorney's office, and then as a senior motions attorney. And he started teaching at Hastings, now UC Law. In 1982, he became an assistant public defender in San Francisco and was appointed chief assistant. So here come the tidbits that I heard. I was interested between Jeff and Karen. Karen didn't speak about this interesting case in maybe if she doesn't hear today, she can do it out in the reception area afterwards. But there were these Irish Republicans who were arrested. And there was this really interesting case that was prosecuted here in the Northern District of California. And she had one of the defendants, and then some panel members had the other 3 co-defendants. And one of them hired Raymond McGrath to be their investigator. Jim hires Raymond McGrath to be their investigator, and love was in the air because she married him they were married for 27 years. The interesting note that I got from Angela Hansen, Jeff Hansen's wife, was that love was in the air for these two also, because Jeff has been appointed 3 times to be the interim federal defender. Once when Barry Portman went to Iraq to help establish a government. Second, after Barry left. And then third, after Steve Kalar left. And one would wonder, why didn't Jeff become the federal defender? Well, it was for love, because Angela Hansen loves being a federal defender, and he didn't, so that she could remain a associate federal defender. So that's the little tidbit. But if Jeff...
The reason I have skeletons in my closet that you can imagine. I would never have survived the Ninth Circuit review. So that was the smartest thing I ever did.
Been in those reviews, I think you would have. But could you tell us, there is an interesting story when the race to open the office happened back at the beginning. So if you could tell us that story, but also talk to us about the evolution of the Federal Defender's Office from the beginning to all of these, days that you've been there, both as assistant federal defender and assistant chief.
What I want to start with is something that is not just, unfounded boasting. You are the Northern District Historical Society. And one of the things that Judge Gonzalez-Roger asked me to talk about is this evolution. But I will tell you that over the years, the 40 years, some odd years I was in the office and saw so much progress, there is no district in this country, and I mean no district, that has given more to the Criminal Justice Act in terms of brains and work and planning and involvement to make sure that indigent defendants were given the best possible representation you can imagine. No district. And I want to tell you why. Very briefly, what the judge just said. You all know the Criminal Justice Act was passed in 1965. In 1970, and they'd just been giving money. What they decided to do after Gideon was give money to folks to represent people who were poor, which is how Billy was paid. And that office was paid. Money was given by Washington, but there was no organized defender program. A weird alliance of 2 very different people, Barry Goldwater and Ted Kennedy, decided it was important. Barry was a big believer in this, apparently, decided in the Senate that we should have an organized defender program. And that was essentially legislated in 1970. The problem was not the idea. The problem was how to implement it. And 2 models evolved. Half the folks on these committees, and Jim did testify, were saying things like we should have a community defender that's not a federal employee, that's not under the thumb of the judges, and that's a bad idea. The other half said, no, if we become an independent agency, Congress can cut off our budget, and everything else. Let's be under the umbrella of the judiciary. Let's make these folks judicial employees, and that way they will survive any kind of scrutiny and budget cuts. They couldn't decide which one to do. And so eventually what Congress said is, we'll give each district the right to choose for themselves. And so you had some districts that became community defenders, San Diego, Chicago, Atlanta, and then you had most of the other districts become federal public defenders, San Francisco, Portland, Washington, et cetera. What was interesting was that Jim Hewitt had become very well known. Senator Cranston at that time had been working with Kennedy and Goldwater to implement this. And he decided that he wanted to have the first federal public defender appointed in the Northern District of California. And I want to be here tonight to say we had the first federal public defender, but we didn't. And the reason why is that somehow in Arizona, Goldwater got, and Jim was all set to get employed. He was chosen, put out engraved invitations, come to the celebration of the first federal public defender in San Francisco, et cetera, et cetera, et cetera. And Goldwater got wind of this and went to the chief judge in Arizona. And I swear to God, in the dead of night, just before Jim was appointed, Arizona had a federal defender sworn in. And to this day, if you go to the website, the first federal defender appointed in the country, and this district was number 2. All right, so Jim was appointed, and what then I want to just talk about is Jim had some failings. I mean, all of us knew this, but he hired me, which was one of his major ones. But needless to say, he really did believe in indigent defense. And over the years, the defenders that we've had have been truly remarkable people. But the contributions that were made, not just by our office, but by the panel, have to be recognized as well, because Jim believed in a strong panel. Barry Portman was rabid about how important the panel was. To him, it was everything, because he believed that people should leave the office, become members of the panel, and that you should not have one institutionalized group that centered criminal defense in this district. And so the panel was already in existence, but when Jim left, it became much more, I think, rigorous in a lot of different respects. One of the problems we had was that we didn't have a formal appointment system to pick people to take cases. There was a woman in our office who ran into some problems and not spreading the wealth, so to speak. And ultimately, that was changed to become a very mechanized system. I asked Ruben Diang to be here tonight. And Ruben, if you would stand up, if you could, please. So Ruben came into our office 37 years ago and has run this panel like nobody can ever imagine, thanklessly, without ever doing anything except doing his job day in and day out, every damn day. And what Ruben has, and what you should all know, I think, is now a very strict system where we have a book. And he'd have to go to 3 panel lawyers and go first, Mary McNamara, will you take the case? No, okay, I'll go the next one. And the only time you could vary from that list of people in order was if there was somebody who was crazy and was firing every one of his or her lawyers. And then Barry and I had permission to call in what was called the fire squad. Okay, which was a group of lawyers who handle the crazies. And Michael Stepanian was supposed to be here tonight. He was a prime example of one of the lawyers who could handle the crazies. But outside of that, we had a very strict system which has been followed and followed so well by Ruben. What then began to happen is 2 things. Barry believed in training, and a few of us were tapped to do training for the new federal defenders every year, where there's a week-long program. And the only reason why I was able to do it, and AJ, who was part of our office, was part of the original faculty as well, was because Barry would say, go ahead and take a week off and go train. And so he would allow us to do that. What then happened is that the AO in Washington began to realize that if you didn't have a federal defender program in your district, the delivery of services to indigent clients was abysmal. And at the beginning, there were only 15 federal defenders scattered around the country, and you could only have an office if you had a certain caseload. That began to lower as the AO realized that they were more cost effective than going to panel lawyers. But when they realized what was going on, the panel and the AO put together, again, I don't say as boasting or whatever, but I was part of that group, and I would go around with other folks as part of the faculty, and it was as abysmal as the AO thought. I mean, we would talk to folks. Some districts like Southern Alabama, if you passed the bar and went in to be sworn to the Southern District of Alabama, whatever, the judge would hand you your first criminal case and say, congratulations, you now have a criminal case to defend, with no training or anything. That was really what was going on here. The AO then decided to institute a much more rigorous training program. And once again, we were incredibly involved in all of the management and oversight of CJA matters that were going on around the country. Jim was our lawyer rep and began to do that. And sitting here, and Mary, if you would stand up as well, Mary McNamara. Mary was our panel rep for 17 years. And later became an integral part of the leadership of the programs out of Washington that made sure that panel lawyers were as competent and able to represent folks as should be the case. Now, as it turns out, virtually every defender office in the country has a training program, and I dare say we were probably one of the first to have one of the most rigorous training programs under Barry. And every year now, if you're going to be a member of the panel, you have to participate in a training program that we put on. And again, that was mimicked around the country by other programs that thought, other offices that thought this was a good idea. And again, it's people like Jim and Mary that have made, the panel lawyers and the oversight of all that's going on with them equally important. And this district, again, I keep emphasizing, was in the forefront of that. The one thing about the panel that's interesting, though, and this is maybe my little story to tell you about it, was that when Barry got into office in 1986, we had a panel, and our people did, I think, better work than anywhere you would see. That created a problem. The problem was the cost per case in this district was somewhat disproportionate to everywhere else. The average at that point was $4,000, which is also a statutory limit, I believe, but $4,000 average for each case. And our district was coming in for these guys at about $20,000 a case. And so the AO contacted then Judge Patel, who was the chief at that time when this was going on, and said, you got to rein in your judges. You got to tell them to stop signing vouchers for $20,000. And Judge Patel was damned if she was going to go to the judges and say, hey, Judge Chesney, cut down on your voucher. I don't want you to spend that much money on the case. And so she called Barry and said, rein in the panel. And Barry said, thank you very much, but I don't think so. And she goes, well, we're costing so much per case. And Barry said, the issue was not why we cost so much. It's why other districts are not doing the job and only putting in $4,000 requests, because that's the problem you got to look at, not our office. And he was adamant about that. And it caused a schism between him and Judge Patel that it was unfortunate because it was an unpleasant time. What that eventually led to, however, because in the original way it worked, Barry was supposed to review the vouchers of panel lawyers. He didn't like it. Nobody liked it. It was a bad idea in Barry's mind. And ultimately, what the court decided to do very wisely again is to create an office, and where we had a court personnel, for Diana here, and you stand up, and you've been, I don't know how long on it. But somebody who the court trusted to review CJA matters, voucher matters, and would make recommendations to the court and sort of essentially rein in the panel, which you've done incredibly well over a period of time as well, and saved everybody a lot of work. But that, again, I tell you, was mimicked around the country. Our district was always in the forefront of developing these innovative programs to make sure that the court and expenses were kept within reason. The final thing is that there were contributions, not just by training things for everyone else, but I just want to mention the contributions by both Barry and Steve Kayla. Barry Portman was begrudgingly, he did not want to be the federal defender in 1986. We convinced him to apply. He applied. He was appointed. That he was later made a part of the oversight group of the federal defenders and became the most influential defender on that program. And I submit virtually anywhere. He was wise, he was gentle, he was kind, and he was smart. And the other defenders around the country saw that. and responded to him in a way that really allowed him to once again tremendously influence the delivery of services to indigent folks. Barry was followed by Steve Kalar, who was a very different breed of cat. Steve knew technology like there's nobody's tomorrow. And Steve decided to try and bring our office and other offices into the 21st century. And he did an incredible job of doing that. And he created for this office a reputation, again, of being in the forefront of how to handle all of the technical aspects of internal regulation of your offices, and then with respect to how you handle things in court in a technological matter, et cetera, et cetera. And he was constantly on the phone talking to every defender program in the country about technical matters. And again, this office was in the absolute forefront of leading the country on some of the most important issues that to this day he's still remembered for. So that's what you asked me to talk about. The evolution is here we are today. It's no fun to practice here anymore. The judges are all nice. Before you guys came here, these old people here, we have 200 years of experience and stories about the Northern District, and we were telling each other all these stories that Judge Gonzalez Rogers said we can't tell you guys because they were inappropriate. So that's where we are.
What I said was, you're telling all these stories about these judges. I feel like I'm a pussycat compared to what, some of the judges that I've heard about. We only have a few more minutes. And so we did want to open it up. Don't know if anyone has questions for the panelists, but if anybody does have questions, we can take a couple of questions at this point. No? No questions? Ruben, do you want to say anything about your role and how important that is? Diana, you want to say anything about your role? No. Mary? Yes, good. We can have a mic.
Mary, excuse me, can I just
Thank you.
give you that? I started in the Defender's Office in 1994, and I want to just say something about Karen, who at the time, a public defender looked like Jeff Hansen, and a very, very beautiful man with a deep, sonorous voice, and an absolute wizard in front of judges. But there weren't very many models, at least at that time, for women. And then Karen was there. She actually hired me while I was sitting in her office, and she got a telephone call from her father, who had just shot something out of a tree and had fallen and injured himself. And I thought, wow, she has a father with a gun up a tree. But anyway, Karen would walk into court, brilliantly prepared, wearing pearls, dressed like she is today, exquisitely. She would speak in low terms. Judges would have to reach out to listen to her, and they would listen to her. She won. She was an extraordinary role model. And it made me think, God, being a public defender, it's not just a vocation, not just a way of life, not just a way to really defend the Constitution, but it's a way to be a beautiful person, a consummate professional, and somebody who's really influenced, I think, not just defense lawyers, but everybody here. So Karen, thank you. We missed you so much. We cried when you left the office. And I know I'm speaking for Ed and everybody who knows you to say you've been a huge influence in our lives. Thank you.
So I have to say, we spent probably an hour before everybody arrived, and I just got stories and stories and stories, and they will extend beyond the 10 minutes that we have left. So what I'd like to then ask the panelists to do, and we'll start again with you, Bill. As you reflect back on where things were when you started as a defender, and I know you're still engaged in defending where we are now, what would you say is the legacy of our defender office here in the Northern District, and how has is there some kind of a thread that that spans the generations.
Well, I think from the very beginning, of what I was describing before, the little one room on the 17th floor, which became, the federal public defender. And I think the legacy of the quality of people's representation was already in process. And when it became a funded office, with a number of outstanding people, almost all was ready. I mean, John Kecker came just as the transition was being made. He had clerked for Chief Justice Warren in retirement. So he came. And then we had Mark Doppel and Bill Goodman and Bill Brockett, a great host of great lawyers. And then, as Karen pointed out, too slowly, women were incorporated and enriched the office the way they did. Penny Cooper was all of our hero, I think, from the moment we knew her. But I think the office had that quality of excellence and determination. And the Jim didn't quite do justice to what the selective service cases were like. I mean, they filled the courtroom. I mean, there was every day, there was a master calendar then. And some unfortunate judge, was the master calendar judge. And, hundreds of people would come, and it would take hours, and it'd be like dramatic performances. Rock bands would come. Joan Baez's husband, David Harris, was a track resistor. And so, Joan Baez came and sang for everyone outside the door. And it was just like that. People yell up and yell at the judge, "Bill Schweigert, you're a senile old fool." When Schweigert did, then the prosecutor would jump and say, "Arrest that man." And the judge would say, "No, he may leave in peace." That kind of thing. And then they say, get his license number. I forget who it is. And all this kind of stuff was going on all the time. It was insane. I mean, and it was, and a guy would get out, the case would be called, and the calendar judge he just want to get on with it, And so the guy would, the defense would go forward, and then he'd say, "You aren't allowed to recite the poetry of Bob Dylan now." And, "No, please, not right now." And, "No, I'm sorry," And he started, and you couldn't stop him. So that was what was happening. It was very, very rich experience. And I think it was unique to our district in a way, because as Jim said, these crazy defenses were developed by this panel. And Jim, is it true in your judgment that panel morphed into the selective service panel once the draft was ended?
You mean the CJA?
Yeah, the CJA panel. Didn't. I think the CJA panel was largely owed a lot to the selective service panel. And these judges, the lawyers on the panel were on the selective service panel. They were money-making big-time lawyers, but they believed they were, mostly draft resistors, sympathetic to the opposition to the Vietnam War. And so they started this process, and they planted the seeds, as the judge was alluding to of excellence, of vigor, of determination. I remember Hewitt, he was a true believer in the. I remember when he'd go to argue in the Ninth Circuit, because we did our own appeal. We just get appeal to me because I like to write briefs and stuff and go argue. And so we went to the Ninth Circuit, and I watched, like, in one case, a guy named Evans. He was a baggage thief at the airport, and so he was caught. Cops busted into his motel room based on a tip, and he was with another man's wife, in compromising circumstances, with stolen luggage all over the floor. So Hewitt goes, "This is a winner." I mean, obviously, there's no reason they could do that. They didn't get a warrant. They had ample opportunity. There was no exigent circumstances. So when it was argued in the Ninth Circuit, they jumped all over Hewitt. He was saying, "Why did Judge Wallenberg, who I have great respect for Judge Wallenberg, well, then why he was appealing what he did? Obviously, he found this unreasonable." And Hewitt going, "Oh, okay." So then we lost. And so Hewitt went to Judge Wallenberg, the trial judge, and he said, "Well, how could this happen?" And Wallenberg said, "Well, you don't understand. Those judges fly up from LA all the time. They hate baggage thieves." And so there was a practical aspect that he didn't always pick up because of his true belief in the system and in the law. But I think he was very good. And he planted the seeds, I think, that that went on for many years. One of the things,
We're getting,
yeah,
we're getting close. I want to give Judge Larson an opportunity to tell us if he thinks there's any, what you think the legacy is here.
Well, I have to say that my participation in the CJA panel and the parallel organizations in state court has really been the most incredible, rewarding, and interesting work that a criminal defense lawyer could ever imagine. I mean, the kinds of cases that we did, we continue to push the limits in spite of the problems with spending too much money. I was going to talk about the goldfish case that I was involved in. This was the first case, it was an importation of heroin from China. First case in which the People's Republic of China cooperated with the United States in a criminal prosecution. 7 pounds of heroin was injected in condoms that were then sold up into decorative goldfish and sent out for shipments to the United States. We had that case and we went to China twice. Co-counsel Gil Eisenberg and Richard Mazer went once. We wound up taking depositions in that case in the middle of the equivalent of the FBI over there. And Judge William H. Orrick Sr. was the presiding judge on that, and this whole thing just blew his mind.
The note to the current U.S. attorney is, when are you going to bring some cases that would involve international travel to interest cases for our defenders?
And then Karen and I were both involved in the IRA cases in which 4 men who had escaped from the Mays prison in Ireland eventually wound up in San Francisco. They were duly arrested at some point, and then the Brits tried to extradite them back over there. Karen represented the first guy and got a favorable result, and then 3 more came along. I told her, if you get any more of those, I'd really like to handle one. So I got the second one, and Jim Brosnahan and Gil Eisenberg had the 2 other guys. We went to Ireland to investigate the case. We toured the Mays prison. We went to the Felons Club for lunch. And all of those cases went to hearing. The last 3 were handled by Judge Legg, who was a wonderful judge. He was politically hip to what the situation was over there. And unfortunately, what happened was the Mays prison was closed. When we went over to just look at it, it was like a country club. The inmates were wearing street clothes. They had conjugal visits. They had wonderful food to eat. They had courses that they could take. Who knows what else they were doing in there? But in any event, we lost in our cases the defense against extradition. We were trying to show that they were going to be persecuted and beaten and tortured and all that if they were sent back there. Well, it wasn't like that anymore. So the case goes up on appeal. And we duly filed our brief, and time went by and time went by and time went by. Mary Schroeder was the chief judge at that time assigned to the case, and she realized that the Mays prison had closed. So she wrote a letter to the U.S. attorney over here. Mark Zedinas was the assistant handling the case. Says, I hear the Mays prison was closed. What good is it going to do to send these guys to a prison that doesn't exist? And he kind of muffed around a little bit and said, well, yes, you're right. So she filed the case dismissed.
Right.
So our 3 guys were set free, and most of them have lived happily ever after, I think. So it's things like that we were involved in. And in the meantime, tremendous camaraderie developed among the panel members. some of my two best friends in the world I've worked with on the panel, tried cases with them, and we're still good friends. The social events are still something to attend. Everybody really feels the spirit of what was started those many years ago and is still dedicated to the kind of excellent work that we can do. So I think we've been an example to districts all over the country, as Jeff has mentioned, and it's been wonderful for us. I can assure you, we all think the same thing.
I hear that every year our defenders have a party for which none of us are invited other than defenders and Judge Elston as the tag along to Judge grandfather. So I agree that there is a great camaraderie. I'm not going to have the two of you give a final word at this point, but there can be plenty of final words. I welcome everybody to the reception and thank again Nancy for hosting that. I also want to thank, as we close up here, the committee that put this program together, Judge Trina Thompson and her assistant Janelle Sampana, Matthew Yelovich, Stephanie Beal, our executive director, Kathleen Winters, and our assistant director, Alexandra Murray. Thank you very much. I hope you've enjoyed it. I'm sorry we didn't have enough time for all the stories I received in preparation for this, but hopefully you can get some of those as we mingle and have some more camaraderie out in the hallway. Thank you so much and good night.